everyone, and welcome to Uncivil Law, with the World channel where we learn from the mistakes of others. As always, if you're enjoying our legal education content, please remember to hit the subscribe button. It helps the channel grow. Today is our weekly question and answer, where I try to answer some of the questions that you've asked over the past week in our Discord, some of the questions that you asked now in chat, and also go over YouTube comments as time allows. So let's get started with comments that were asked in our weekly questions channel on our Discord. Here are the questions that you have asked in the last week. Botanic says, since the TCPA makes it so that if they raise the defense, this is the Texas Citizens Protection Act, the Anti-SLAPP Act, you basically have to file an amended complaint, assuming you don't preempt the issue, as standard charge on your pleading after the failing of the suit. Could you argue that as a matter of right, it gives you a law to file an amended complaint? Meaningful opportunity to respond, due process, or something like that. Well, the TCPA itself gives you an opportunity to respond. You can put it in your motion, in the responsive motion. So you can either do it in the original thing, which you probably should to preempt the issue. You could file an amended complaint, which you probably shouldn't do because you don't want to lose that opportunity. And you can also, if you haven't thought to do it otherwise, you can just spell out more detail in the motion to responding to the TCPA. So the TCPA itself, it gives you an opportunity to respond, and that's where you can spell out the stuff in more detail to deal with that. So that's the way to do it. But I think it's much easier just to do it on the front end, because you're in control of when you file your own lawsuit, but you're not in control of the TCPA timelines. You know, the TCPA provides some mandatory timelines. So if you file the thing first and then get hit with the TCPA, you have to respond to those deadlines. Whereas if you just do it on the front end, there are no deadlines because nothing's been filed yet, except for, of course, statute of limitations. But yeah, the TCPA itself gives you a meaningful opportunity to respond, so it's not a problem. The Slate asked, do you think rights are innate to the person or they're granted by the state? In your stream with Nate, you said that rights are nuanced. It would seem that to be a right, it would have to be absolute. Something being nuanced and something being absolute are not in contradiction. The only question there is, what is absolute? What is absolute? And so to say something is nuanced is not in conflict with saying something is absolute. There may need to be a balance your right against a societal interest, and that may require nuance, but it would seem the right itself is absolute. Well, once you're balancing, you're not in an absolute right, or if you are, once again, you're trying to define where the boundary lines are of that right. If right can be modified, it seems like it's a privilege rather than right. Yeah, again, I think there's a confusion here to suggest that a right, saying that a right is nuanced is different from saying that it belongs to you in its full measure. It would be a little bit like saying you own a piece of land and me saying the boundary line to your land is here, not here. And you saying that's not fair. The right to my property is absolute. And I'm like, yeah, but the boundary line is here, not here. Right? So to say you have a right to something doesn't in and of itself define the scope of that right. So to say, well, your piece of land is not nice and square. Your piece of land has lots of little jagged edges and all kinds of contusions and all kinds of things. So to say what the scope of your land is kind of nuanced. It's not so easy as saying, well, walk 20 feet that way. You know, it's more nuanced because of all the different things that have happened to your boundary. But yeah, whatever you have left, you have the right to, but it doesn't make it non-nuanced. So I think you're seeing a contradiction where I wasn't intending to apply one. Ashroth says, what is the point of the Bill of Rights if the government doesn't even pay lip service to it? When it fringes, I don't know why you put fringe in quote marks rather than infringe, but okay. When it fringes of speech, when your fringes of speech involve extremely high bars to meet, but the bar for the Second Amendment fringe is, as the Second Amendment says, there's no right to carry arms openly in public, nor any such right within the scope of the Second Amendment. In direct violation of bearing arms, in a state that almost never approves concealed carry permits, in direct violation of Heller, Miller, and the literal text of the Second Amendment. Well, first of all, it's not in violation of Heller or Miller. Heller and Miller only dealt with the right inside the home. So you can't say that what California is doing is in violation of Miller or Heller, because Miller and Heller wasn't addressing this in any way. And kind of answer to the previous question, to say that you have a right to bear arms doesn't inherently define the scope of that right, any more than saying you have a right to a piece of land inherently inherently defines the boundaries of that land. So yeah, you have a right to bear arms, but what are the boundaries of that is not inherently defined. And it's like, well, the text says bear. I'm like, yeah, but the text also says you have the right to the property at so and so and so and so. But what are the boundaries of that? It's not, it doesn't inherently tell you what it is in and of itself. To say you have the right to the piece of property known as Blackacre, right? It's saying that you have the right to bear arms is a little bit like saying you have the right to the property of Blackacre. As every law student and law graduate knows, you saying that you have the right to Blackacre in no way tells you what the scope of that is. Kratos asks, in response to Lil Nas X versus Nike, what case would Nike reasonably have against Lil Nas? Well, the one they brought is the one that they should bring. It's most logical case. It would be a lot more helpful if they brought better evidence of confusion, which they didn't really do in their complaint. But the theory that they're going for is the right legal theory. The evidence they have to support the theory leaves a little bit to be desired within the scope of the complaint. Question 2. Surely Nas is utilizing Nike manufacturing, the logo, brand awareness, basically everything to sell modified shoes. Isn't that infringing on something? That's what Nike thinks. Yeah, but if you're selling customized Nike shoes and everyone knows that they're customized Nike shoes, the only thing here that's at play is the potential deception of the customer. So if you are selling modified Nike shoes and everyone knows they're modified Nike shoes, then I guess in some sense you're hijacking the brand recognition of Nike, but you're allowed to do that because no one's confused by it, right? So that's kind of the problem and the conflict. Kratos asked question 3, what's to stop me from buying a bunch of white t-shirts with a Nike logo on front from Nike, putting my blood on it and in my name? I get once you own something you can modify it, but personally buying 666 and bulk modifications can't be right. The legal theory doesn't change. Really, fundamentally, the legal theory doesn't change from 1 to a million. The impact that we have more consumers involved, so the probability of consumers being confused is somewhat augmented by the number, but the underlying legal theory isn't really different from 1 to a million. It's like, yeah, if it's one, it infringes, and it also goes to damages. If one is being sold in a way that hurts Nike's rights, then presumably the damage of one is a lot less than the damage of a million. So it might go to damages, but it doesn't really change the underlying legal theory. So I don't think that bulk buying and bulk modification really changes as opposed to a one-of-a-kind custom. The most operative question at the moment is the consumer of the one or the consumer of the 1 million confused as to the source of goods? So I don't think the bulk buying really changes the legal analysis. Number 4, why doesn't Lil Nas and M make their own trainers? They want Nike logo design, but don't pay Nike to use them. I think people know it has nothing to do with Nike, but buy them because their Nike trainers have been modified. I don't know why they don't do that. They could do that. This is what they chose to do. Whether or not that's a legal thing for them to do is the question that would be decided. So yeah, had they chosen to make their own trainers, without any of the logos and that looked the same, then yeah, they would have been better legally, but they didn't choose to do that. So the question is, can they do this? They definitely could have done that, but they didn't choose to do that. They did this. So, I don't know what to tell you. Botanic asks, is the likelihood of confusion on a trademark based on the buyer of that product or by any product of the company? In the Nike suit, it seems if the likelihood to confuse any Nike consumer because it's better for Nike. If the consumer that wants you, they're dead. Yeah, that's exactly the problem. Like, who is the relevant consumer in this market is going to be a fight between Nike and Lil Nas and the M company. Who is the relevant company? Or who is the relevant consumer in this exchange? So presumably the relevant consumer could be anyone who buys any Nike products. It could be anyone who buys Nike shoes in general, or it's someone who would be buying this particular shoe. So trying to find the relevant consumer is definitely going to be part of this and part of the issue. And if you show, if you can show enough, you can show the damage either way. And so it just becomes what's more advantageous. But yeah, fighting over who's the relevant consumer is going to be a big part of this question for sure. Let's see what questions we have so far from the bot. Not very much. Melissa Boomer of the Night says, how are you? I'm doing pretty well, all things considered. Thank you for asking. LK says, thoughts on using a historical thesis to interpret law versus a textual examination. Reading the Young versus H.I. majority opinion had me tearing my hair out. Well, when you're using historical stuff, you're using it, at least if you're an originalist conservative, you're using it, if you're using contemporaneous stuff, you're using it to understand what the language meant at the time. And so you're trying to understand what certain words meant. So when you're looking to contemporaneous sources, you're trying to get a better understanding of what the language meant at the time, because language changes and evolves. So if they use a particular word at a particular time, it might not be the same thing. So it's not exactly that you're incorporating the stuff, but you're reading it in light of, to borrow a patent idea. We read in patent law land, we read claims in light of the specification, but not limited by the specification. So it's the same idea, maybe. We're reading reading language in a law in the light of contemporaneous writings, talks, to help us understand what it means, but it's not limited by that. The only thing it's ultimately limited by is the text. So using contemporaneous writing or historical writing to understand the text is valid as far as it goes, but yeah. Hand Moist Thunder Nipple says, can I put your new slimmer image on a t-shirt and call it the Nas Killer? No, please no. I do not want that. Also, incidentally, if you did that, you'd be interfering with my right of publicity. So there's that. So no. Great. Let's add, since there's no other questions right now, let's answer some previous comments from the YouTubes over the last couple of days. So let's see what we got. Roses in Blue says, I'm confused. The amount of money the company has to hire the best trademark lawyers in the business, and they chose to pick random anonymous comments online that don't even refer specifically to the shoes. I know, right? If this is the best Nike has to work with, Nike has a problem. Why do they pick these particular examples? They would suggest these are the best examples they could have, and if these are the best, it's not really looking great. Can Nike argue likelihood of confusion is high because they have a history of collaborating with athletes and pop cultures, especially since Lil Nas has an X on the end, and that's often how collaborations are presented. Name X Nike. People not familiar with Lil Nas might read it as Lil Nike X shoe. That would be valid. It wasn't raised in the complaint, but that would be a basis to argue confusion, that this is how collabs, Nike didn't go into these details, right? So I can only, as always, just evaluate a case based on the legal filings that are before me. This is what I do in every case, right? I try to evaluate before me. So yeah, if Nike had said, people would be confused by this because we do a lot of collabs with artists and singers, and so people would think it, and this is normally how we market our collabs. And in light of that, people would think that this is more likely to be a collab. And also, incidentally, here's examples from social media where people are making exactly that kind of mistake, right? They're saying because it says Lil Nas X Nike, it's a collaboration, right? If Nike had argued those things, that might have changed the legal analysis. But Nike didn't argue those things. So I'm evaluating the lawsuit as it currently exists. So you may be smarter than a Nike lawyer. LK says, reviewing contemporaneous writing of the time, laws may I can understand. Going through 600 years of gun laws is completely different. Not really, because, again, when you're talking about the Second Amendment says the right to keep and bear arms, right? So the word the is a definite article. It's the difference between saying I want a apple and I want the apple. If I say I want a apple, any apple will be fine. If I say I want the apple, I'm referring to a specific apple. There's an antecedent basis for it, right? It's a particular apple. It's a definite article. So the right to keep and bear arms is different than a right to keep and bear arms. The right to keep and bear arms is informed by what the right was at the time of the founding. In order to answer that question, yeah, go consult 600 years of English common law, because that was the right as it existed at the time. So yeah, that's why you do that, because it's the right as it existed in the common law. So go consult 600 years of history to help you understand. Yep. Lauren Meyer says, if you could, would you redo and attend law school now or not change anything at all? I'm not sure I understand the question. I liked law school the first time, and in some ways I'm doing law school now, because this is very similar to law school in a lot of ways. I'm reading cases from lots of different domains, which is law school, right? You're reading cases from kind of all kinds of domains, becoming a generalized lawyer, and then sometimes you become more specialized. And I've spent a lot of years in a specialty. So some ways it's kind of like going back from a specialty of medicine, going back into general practice, which I assume happens. So it's like in med school, I assume, I don't know for sure, but I would imagine they generally teach you to be a general doctor, and maybe later you get specialties in residency or something like that. And it would be like a person who is a specialist saying, you know what, after all, I just want to go back into general medicine. And so it's just being like med school again. So I liked it the first time. It worked out well for me. So I'm enjoying this for whatever it's worth. I'm enjoying the legal stuff. It's a lot of fun. Kurt, quick question. I was thinking about some of the decisions that have been handed down to us from the courts. Does the idea of a convention of states? Okay, whoa. Yeah, right there, it's like, right there we can stop asking the question. The moment you start talking about convention states, I get super, super nervous. The reason I get super, super nervous is we've never had one. So I don't know what one would look like, right? And I don't know what it would be. I don't know how it would go. And so it makes me super duper nervous, because it's like I have no precedent for this. The last time we had something that could be vaguely thought of as a convention of states, we abandoned the Articles of Confederation and adopted the current Constitution. So, that was kind of impactful. Would a modern version of that be the same? I don't know. I'm not 100% sure. I want to find out. So I have a lot of skepticism on the Convention of States ideas. I'm not sure it's a good idea. Yeah. Melody says, your intelligence is admirable. Well, thank you very much. I appreciate it. Joseph says, totally random, but legal. What movies do you like that don't have to do with law? My favorite movie of all time that doesn't have to do with law, well, it kind of has a little bit, I guess, to do with law, although it's more PR, is Thank You for Smoking. Great movie. Thank You for Smoking. Not very well known. I liked Shawshank Redemption very much. I liked Brewster's Millions. Actually, I can just hold on. Let me, because I have a running list that I have of movies that I like. So let me just check to see what I have in my list. The James Bond movies, some of them, especially You Only Live Twice, is probably my favorite James Bond movie. Back to the Future, the movie Blow with Johnny Depp, good one. And also in that vein, The Ninth Gate. I've actually been watching clips from The Ninth Gate recently. It's been coming up in my YouTube feed. Roman Polanski. Strange movie, really interesting. I actually was watching them before the whole Nike shoe debacle, so I don't know what that means about anything, though. I was watching The Ninth Gate, and then the shoe debacle happened. I'm not sure what that says, but that was a thing that happened. Down Periscope with Kelsey Grammer, fun movie. Fight Club. John Wick movies. Let's see. Mission Impossible's movies are pretty good. See what else is on here that I really like. Lord of the Rings is good. Trading Places, Coming to America. Yeah, those are probably a lot of favorite movies. Have you ever seen Benny and June? Are those the puppets? Benny and June? Are those the puppets? If so, then I know what it's referring to, but I've never seen it. Yeah, so this is, again, going to a question we answered a little bit earlier. My question is, does consumer confusion test only relate to people who bought the shoe, or are the segments in which Nike is held by general public potentially being alerted as a result? Yeah, who is the relevant market is going to be a fight. But it doesn't really matter at this exact point because Nike's lawsuit is so lame, right? Is the relevant market the people that bought the shoe? Well, if Nike can show confusion there, Nike wins, right? So the best possible scenario for Nike is to show confusion by the people who bought the shoe. That would be great for Nike. That's their best possible legal position. But if they can't show that, because how could they, one would think, because they're $1,000 for the shoe, how stupid can 666 people be? Really stupid, unfortunately, we know from Uncivil Law. But we'll give them the benefit of the doubt for the moment. So is the relevant market the people who bought the shoes or people who buy shoes in general? People who buy Nike shoes or all shoes, or people who buy Nike clothing or all athletic clothing? What is the relevant market? That's going to be a fight. But at the moment, it doesn't matter because Nike was really lame in their complaint. So hopefully it'll get better. Cody Sam says, why do some lawyers still have effective full-service libraries, full textbooks? We're in the digital age. Aesthetics? Probably. Almost certainly it's aesthetics. Is there a reason to have hard copies? Not particularly, except for there's reason to have hard copies of some things, like having a hard copy of a horn book or a treatise. It can be it depends what you like and when you like it. But yeah, like I wouldn't use a physical book for case law, but I might use it for a horn book or a treatise, which basically is a book that tries to cover like all of a subject. So like it could be a book on patent law or a book on civil procedure, right? So it's like basically kind of like an encyclopedia sort of, but it's like one thick book. So it basically covers every subject kind of, and then like you can read it and it would give you a quick thing and then tell you where to go. So it's like a immediate, here's the general subject, here's some big cases, now go do more research. So I might have something like that in paper, but I personally wouldn't use a case book or books of cases. I wouldn't use the Federal Reporter in paper. But yeah, that's me. Lauren Meyer says, why did you ask Nate about felony murder in a bank robbery? That shit blew my damn mind. Okay. The reason I asked the question to Nate was because I was having a fight with someone in Nate's chat, which was really irritating, right? So I was only there as a guest, and I was having this fight with this guy whose name I don't remember in the chat on like felony murder. And I can't remember exactly what the discussion was, but basically we were talking about like what felony murder could or could not be. And I said, if all you have to do is show that you're a cause, not the cause, right? So all you have to do is show your approximate cause. And some states will say like a substantial approximate cause, but either way, right? To show that you're a cause, not the cause. It's like, there's not cases that say that. I'm like, and then I said an example, like, so to make the example, I said to him, well, if you robbed a bank and someone died of a heart attack from the stress induced from the bank, right? The bank robbery is the felony. The person died. That's felony murder. And he's like, no, it's not. I'm like, yes, it is. I'm like, no, you can't find any case. You can't find any case that says that that stress and a heart attack is a felony murder. I'm like, I said to him, I've been a lawyer for 14 years. I'm telling you. It's like, find me a case that says this. All right, fine. So I cite this case from Kansas, and he says, and which deals with a heart attack, and the guy died with a heart attack from a felony, right? And he's like, well, that wasn't the person scared. That in that case, the person was bound and tied. And so that's not the same thing as the person merely being scared. I'd never hire you as a lawyer because you didn't give me the case I wanted. I'm like, you have got to be kidding me, right? I find a case from the Supreme Court of Kansas. The guy dies from a heart attack. It's felony murder. The conviction stands. He's like, well, it wasn't, I don't think it was a bank robbery. I can't remember exactly what it was. But it's like, well, this wasn't the bank robbery. This was a guy merely being scared. He was bound and held, and that's totally different. I'm like, go F yourself. So the reason I asked Nate was in the hope that Nate, confirming the answer that I already given, would somehow convince this guy. So I asked Nate, like, please do me a solid and tell me that if you intend to commit a bank robbery and don't intend a person to die of a heart attack, that the heart attack is felony murder. And he's like, well, if I'm understanding the question correctly, which he did, he's like, yeah, that's felony murder. You know, you don't intend the heart attack. You do intend the bank robbery. A person dies in the result of that. That's felony murder. And then the guy who's being super, super salty with me is like, well, I wouldn't hire either one of you. You're bad lawyers. And I'm like, I don't. Why are you here? Why are you here? I have 14 years of legal experience. Nate the lawyer has about the same. I don't know exactly when he passed the bar, but roughly the same amount of legal experience. You got 30 years of legal experience here telling you you're wrong. Why are you here? And then I cited him at the end of the chat, an article from California where it wasn't a bank, but it was a fast food restaurant or a dining restaurant. So I was like, here's an article from California where it was guy goes into restaurant to hold up the place. Guy dies of heart attack, 25 years. And he never responded to me, but because it was right at the end of the chat, but I was just waiting for well, this isn't in a bank. That's not the case I asked for. You guys are the worst lawyers ever. And I'm just thinking to myself, why are you here? Why are you here? You have got 30 years of legal experience telling you that you're wrong. Why are you here? That's why I asked Nate the question, because I was hoping if Nate confirmed the answer, which I knew he would, because I know it's the right answer, that maybe it would shut him up, but it didn't help. So, yeah, that's what happened there. If there are multiple signed versions of the Constitution with commas and different spices, yes, it was accepted to be the same document. The commas don't matter except where they're uniform over all copies. No, that's not necessarily the conclusion, and no one knows what the conclusion is exactly. You know, we're not quite sure what the answer is on that one, but no. Oh, also, incidentally, the reason that I know this, by the way, the reason I know the answer is no, and you're going to have to take my word for it, because, again, I've been a lawyer for 14 years, so I'm going to tell you something, right? And find me the thing that says this. All right, I'm going to tell you, all right? In the process of passing amendments to our wonderful Constitution, in the process of passing amendments to our wonderful Constitution, and as I'm sure you know, that you need three-fourths of the states to sign off on it. And so the various states who have passed off on the various amendments have a bill somewhere in their system, right, that says, we want to pass this language as part of the Constitution, right? This is the proposed amendment. We'd like to adopt it, right? And as may not surprise you, the various legislatures of our great nation have, on a not infrequent basis, said, we want to adopt this constitutional amendment, which is not exactly the same text that Congress passed. It's only a constitutional amendment. It's not like it's that important or anything. But yeah, this has happened multiple times, where the state legislature has said, we want to adopt this text, and it's not the text Congress passed. Yeah, so someone had to figure out, well, geez, they signed off on it, but they signed off on different texts. So is this part of the Constitution or not? Because they're idiots. When they signed off on the 14th Amendment, for example, and couldn't recite it because, I don't know, they couldn't be bothered to get it correct because it's not like it's important or anything, does that signature count? And the answer was yes. So even though they didn't sign the exact same copies, is not part of it's still part of the Constitution nevertheless. So that's the reason I know the answer to that, because we've had this happen before on other amendments. Because, I don't know, we can't be bothered to get the text right. So someone had to figure out if it counted, and we determined yes. Hans Most Thundering Nipple says, having red hair discounts your legal experience by 3 years. Fact. I'm not sure how that works. Melissa Boomer Knight says, the Chauvin fallout had me thinking of an old book from grad school, Thoughts on Rawls' Theory of Justice. Yeah, Rawls' Theory of Justice is really, really interesting. So, it's a really interesting theory of justice. So, excuse me, one second. Excuse me. So, John Rawls proposed this thing called the veil of ignorance. And what he said was, let's go behind the veil of ignorance. And we're all going to collectively vote on what kind of society we want. So there's certain things that we don't know behind the veil of ignorance. Like, we have all the knowledge we have, but there's certain things we don't know. These things that we don't know include, like, what sex we are, what race we are, how much money we have, what our health is, kind of details like that, So we know, like, all facts about the world. We know, like, all the facts and all the things that we need to know. We just don't know anything about ourselves. Does that make sense? So yeah, that's the veil of ignorance. We don't know anything about ourselves, but we know all the facts we need to know about the world. And so John Rawls said that the just society would be one where from this position, we would all collectively vote on what the just society would be without knowing what our position is. So without knowing what our position is, would you vote for this society or that society, not knowing what end of the equation you'd be on? And so it's an interesting idea. It's an interesting philosophical theory. And I think there's some validity to that. It doesn't really answer the question completely, because even if you didn't know anything about yourself in sort of facts, people have inherent personality traits. If you buy someone like, what's his name, who wrote the Blank Slates, which basically was written to prove that people don't have blank slates. So people aren't born with no predispositions. People are born with inherent predispositions. And it was the whole point of the book. And so even behind the veil of ignorance, even if you didn't know anything about yourself, you'd still have predispositions. So some people would want to be gamblers, some people would want to be risk takers, and some people would still be conservative. So even behind the veil of ignorance, your personality traits would still vest. So I don't know if John Rawls really fully account for that, but it's a very interesting idea. It's like, rules would you want if you didn't know what the rules, how they would apply to you would be? It's a pretty interesting idea. It's an interesting idea. I'm not sure though, that given that theoretical exercise, how it would be different from our current reality, if at all. And that's also something Rawls, I don't think, really fully dealt with. He didn't really seem to consider the practical impact. Like, if that happened, what, if any, differences did Rawls thinks it would make? Is not immediately obvious to me. Or then maybe, again, I don't know Rawls' work well enough. Maybe he did answer that question. But it's like, he didn't seem to, based on my understanding, answer the question of what did he think that the result of that would be, or how it would be different from our current reality. But it's an interesting idea. And Melissa Boomer Knight says, on all caps, which Melissa Boomer Knight is going to fast learn is not within our rules, right? I'm so glad to hear someone really gets Rawls and not just rail against him. I do read. I do read, and I do try to understand. So yeah, Rawls, it's an interesting idea. I'm not sure how it makes a difference, but it's an interesting idea. I love the pronunciation of Nas as Nez. My reputation for pronouncing names continues to fly deep. The inverted cross is also a sign used in the Illuminati. Okay. See if we can get past the shoes discussion. Yes, you can bump fire a semi-rifle without any accessories. Okay, well, even if that's true, I don't think it makes the logic of we can ban tools that would massively assist in this any less invalid. But okay, sure. You can bump fire a handgun without any tools. I still don't think it necessarily means the ATF can't interpret the regulation and then say, we're going to ban tools that would assist in this purpose. I don't think that quite follows. While the set, okay, so this is in response to my claim that 12 Angry Men is the best legal movie of all time. While the setting as such is in a jury room is more about the human condition, our preconceived notions of what truth is, who is likely to tell it, duty to society, and critical thinking. One can hardly draw any law knowledge by it. No, that's true for sure. Not a hint of how law works. That's very true. I mean, that's fair enough. So, yeah, it's more about the human condition than about law. I guess that's fair criticism. I'm still not sure which is best legal movie. If you want to learn about law as such, probably Rainmaker. If you want to learn about law, that's probably the best. It's also a really good movie, incidentally. All right, so let's see. In response, Dante says, in response to my video, the concern over potential abuse of power if the executive can define crimes predates our nation's founding. Yeah, that's basically Magna Carta. Yep, basically. It says both opinions are strong. Why the Supreme Court needs to weigh in when the lower courts have their say. I'd argue if both sides have a solid argument, that should definitely be a case. Yeah. The DC ruling makes sense. I think it's not unreasonable to have something like Chevron deference on a couple of cases. First, as mentioned, one of the cases that the ATF has to make the ruling for an extended period of time. It seems reasonable to let it stand. Second, if there was process, more lightweight than creating legislation, where the legislature could signal their agreement, I think that should get deference. I think the saddest part about this is it seems like it's the legislature's fault. It's definitely the legislature's fault. The legislature could, law, instead of letting the executive agencies do it, and we wouldn't have this problem, but they don't. So, yeah. Hand moisture Thipple Hands says, are you going to do any more of the Jan 6 arrests? Yes, as time allows. Shavi 152 said, would a vaccine passport be legal under HIPAA, PHI? Yes, probably, almost certainly, because a diagnosis of COVID is not protected by HIPAA because if it's high transmissibility, it's not within the scope of HIPAA. One should go read the details of HIPAA. So, yeah, it's not protected information. This is incidentally why when they diagnose you, they can report your ass to the state. HIPAA does not apply. So sad. People misunderstand HIPAA, which is not surprising. People misunderstand all the laws. But like, oh, HIPAA means privacy of health records. Yeah, but, like every law ever, asterisk, 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 asterisk. Yeah. Kurt said, I want to come in late and said, if you want to do the crowdfunding to file a brief, I'd go 500. Yeah, I might have slightly inflated the cost of the printing. It's probably more like 5,000 than 10,000, but it's still going to be expensive. In response to the Maya Cohen story, which somehow the judge still has not decided on, all these many months later, it's still pending somehow. QI, it's recognizing a legit problem. It's like you live in a log cabin in Minnesota in the dead of winter. It's cold out. QI is a fire you try to start at a fireplace, but the QI spread. Something like that, I guess, yeah. People continuing to tell me that they can bump fire a gun with no external equipment. I believe you. I'm not sure it makes the ATF's interpretation any less reasonable, though. A little after 1815, I can't hear the Supreme Court is a perfectly balanced legal system with absolutely no exploits. Yeah, that's really good stuff, yeah. We'll skip some bump stop stuff because in response to answering that Ohio bar exam, which we finally got to the end, loving diverting video on civil makes me consider whether I'd love law school. I don't know if I could incapacitate anyone from a distance with a stapler, but it wouldn't be potentially lethal, and I'm a med student. Well, you never know. Eggshell skull and all that. So, I want details. Well, this is not a med school exam, so we're not going to get into further details on his medical condition. But, also, why would you dare to call anyone crazy who's pointing a gun at you? The mysteries. That's a good practical question. I don't know. Melissa Boomer in the Night says, I didn't. Thank you. There are nuances on Rawls that my husband and debated over the years, but excellent shorthand take. Great. I'm glad I at least understand it on a surface level. Everyone forgets about the movie Jury Duty. First blood, the fire nuances of the legal process. Not sure about that. Paper Chase is Nomination My Cousin Vinny is a much better thing. Yeah, Paper Chase is a good law school movie. It's not a good law movie. But if you're going to law school, it's a good movie. It's a little less accurate these days than the day it was filmed, but still has some truth in there. My torts professor was very much out of that. But then again, my torts professor was very old. Yeah, so in response to this personal jurisdiction, I said it was a 5-3 decision, but it was 8-0. Yeah, you're right. I misunderstood. It was an 8-0 decision. I misunderstood. I thought those three were dissent, but no, they were merely concurring. So you're right. It was an 8-0 decision, failed by uncivil law on my ability to count. Now, this is really interesting, too, because this is dealing with the Ford personal jurisdiction case and whether or not Ford could be sued in Montana and Michigan for various vehicle accidents, right? So Steve Leto of Leto Law did a video, and he said that the argument from Ford was, I'm going to paraphrase here because I can't remember the exact word choice he used, but he said it was one of the most dumb or insane or completely mind-blowing arguments ever. Like, who would think that this makes any sense? And he said at least that the lawyers that he talked to thought likewise. They all thought this was cuckoo for Cocoa Puffs insane. They all thought it was horrible. And your boy on civil law here thought, actually, no, it's kind of reasonable. It could win. I thought it was a pretty good argument. I thought it might be a winning argument. Now, obviously, it didn't win to the tune of 8-0. I don't remember how I predicted it. I'm not even sure if I made a prediction on it because I couldn't figure it out. So I'm not even sure if I made a prediction. But either way, I thought, it's actually a pretty good argument. It might be winnable. And then an 8-0 decision tells me no. Although then again, the Supreme Court's been unanimous and wrong before, right? So, yeah. And then Steve Leto says he thinks it's dumb, and he thinks every lawyer that he knows thinks it's dumb. And I'm like, what does that say about me? Well, I'm like, actually, this kind of is a good argument. Kind of makes sense. I think Ford might have something here. I don't know. I still don't know what to think about it in terms of, does that mean I should correct my thought process in some way? And Steve Leto thought the argument was insane. I'm like, it might be workable. I don't know. I'm not sure what it says about anything, but yeah. Who the hell was screaming in the background? Oh, on that video? Yeah, that's just street noise. Yeah, I do live in the city, and every once in a while there's some street noise. So who was screaming in the background? Street noise. Definitely should have looked in response to Legal Happy Hour with Nate the lawyer, he says, definitely should have looked into Legal Pal's actual findings instead of the headline. Well, my friend, had you searched my channel, you would find that I had, in fact, looked into the legal filings. And, yeah, so no. But thank you for the suggestion anyway. In response to personal jurisdiction, I agree with you. But I just want to make the comment, if personal jurisdiction doesn't give them jurisdiction in Montana and Minnesota, but personal jurisdiction does, specific, then isn't that the same? Yeah, that was kind of my critique. Isn't it just turning into general jurisdiction? That was my critique. So doesn't that blend the concepts? So, yeah. What got changed? It looks like the rule changed to allow plaintiff to sue from their state of residence so long as defendant does substantial business in the state. Yeah, kind of, sort of, which is kind of a change. Because before, it had to be like, the state, they had to do something with respect to the product in the state. And now it suggests that, it's good for consumers, but the logic of it was a little bit challenging. But, I'm at 1506. I have to say I don't mind. Product liability laws effectively eliminate specific jurisdiction as long as it only as the state where problem accident happens to general list. That's a fair resolution too. That's a fair resolution. Joseph asked, does Steve... Why didn't it pop up in my feed? Joseph said something with a comment at Uncivil Law, and it didn't pop up in my feed. Interesting. But I'm looking at the chat. He says, Leto doesn't know you, though. No. Yeah, no, he doesn't know me. We've never met. I wrote him a letter one time, and he ignored me. It was very annoying. In noting that I repeat my phrases a lot, Rita Joe says, regarding repetition, almost all attorneys I know do this. They often repeat things 2, 3, or 4 times. It's nice to know I'm not alone. In response to the personal jurisdiction thing, having read 2 concurrences now, I understand what the argument was about. All 8 justices agreed Ford could be sued, which does appear to be a departure from the regime we all studied in Civ Pro. If I recall correctly from 9 years ago, and I'm having to go even further back, we even talked about this to an extent. If the product exited the chain of commerce outside the forum state and then brought into the forum state, the manufacturer would have to be subject to general jurisdiction. That was sort of what I thought. This would mean that 2 identical cases differ only in where the car was first sold would have different outcomes. That would be the result, yes. The people injured in Montana by defect in Ford sold in Washington would be out of court. People injured in Montana by identical car sold in Montana would have jurisdiction. Put it that way, it seems absurd. Maybe not, but, if we're, based on our understandings of personal jurisdiction, that would be the logical conclusion of that. It's like 2 identical vehicles, you can sue over one and not 2 identical vehicles have the same accident in the same place, and you can sue in Montana courts and not in one case and not the other. Is that an absurd result? I don't know. It would be the result that would follow from the logic of it. So the 2 concurrences, Alito and Gorsuch, both appear to say that no change in the law or its interpretation is needed in order for Ford to be sued. They say arising out of or related already includes the cases where cars were purchased outside the forum states. This seems like a disconnect to me. We always focus on the arising out of, and it seemed that we would have expected at least some causal connection. The concurrences says this interpretation would have been wrong or misguided, and that cases like this already would have been viewed as related. Yeah, I'm not so sure about that. And one of the reasons I know that, at least in part, is because the Supreme Court took the place in the first place. It's like, yeah, this has always been the law. I'm not sure I'm buying that. They both criticize the majority for making a twofold analysis. Rising out of one analysis and relate to is a new thing. Yeah, I'm not sure yeah. In this light, I have to say, while I find the judgment surprising, it really doesn't bother me if Ford gets sued. Yeah, I'm not sure that it screams against fundamental principles of justice. It just is a different conclusion. If our Washington State boutique car manufacturer didn't have a commercial presence, it would offend traditional notions for them to be yoinked into court in Montana. But since Ford Market sold the same make model, and then one might ask the next logical conclusion, what if Ford doesn't? Because I don't think Ford sells all their cars at every place, even in the United States. So what if Ford doesn't sell that particular model in that particular state? Does it change the analysis? I suppose that we'll have to wait for another day. Allowing Ford to duck a lawsuit in the plaintiff's chosen forum isn't really justified if a differently situated plaintiff would have succeeded. I'm not sure that necessarily follows, but okay. Ford already can't foresee being sued in Montana over a case like this. Yeah, that's true. And the origin of the Horizons object shouldn't matter. All 8 justices signed on to this. There's no dissent saying Ford should have won. Yeah, I misread that. So it looks like this is just barely shy per curm. Yeah, but, you have to there is a slight mistake there. Per curm doesn't mean unanimous, and just to correct everyone in the chat. So it's just short of being like unanimous because there's no unanimous, no single opinion. But per curm doesn't mean unanimous. Per curm just means it's issued in the name of the court as a whole. And while that sometimes is unanimous, it's not always unanimous. In fact, one of the most famous per curm cases of all time was distinctly not unanimous. That would be Bush versus Gore, for example. Why is it per curm instead of not? I don't know. I don't know how the Supreme Court decides these things. But yeah, that was so just per curm doesn't mean unanimous. Per curm means that the person that is authored in the name of the court. I don't know what that difference that makes practically, but yeah. I'm happy to see you look less depressed lately. Thank you. It's awesome. I appreciate that. Thank you. I find it odd that a textualist ignores half the statement, connecting the Second Amendment to the militia. I know it's been ruled on previously, but it doesn't mean those rulings are correct. No, it doesn't mean that they are correct, but I think they're correct because the preamble in Article 1, Section 8, Clause 8, and the preamble to the Constitution are treated the exact same way. And so I don't think the logic of those decisions, so I agree with it. So I think it is a preamble and not operative text. So yeah, I'm not ignoring it. I'm giving it exactly the weight it's due. I interpret it as a prelude, non-operative text rather than as operative text. I that's as a preamble. So I agree. I'm not ignoring it. I'm giving it exactly the weight it's due. So, in my view, yeah, go away. My number 1 and number 2, 12 Angry Men and Inherit the Wind. Yeah. In number 39, didn't even get his name right. Well, it's not exactly the first time. A Few Good Men, I hate. Not accurate. No, it's not even close to accurate. It's a horrible movie. I hate it. And I don't even like the movie from its own terms, to be quite honest, because of Demi Moore's character. This is not a slight on Demi Moore. It's a slight on Aaron Sorkin, who wrote the movie or wrote the play or whatever. But it's a slight on Aaron Sorkin. Demi Moore's character is just horrible in that movie because she is so is like covering her ass the whole way. She has no real she has no real beliefs. She's just always covering her ass, and she's contrarian. Because the way that I know that, by the way, is there's 2 big scenes that make that clear, right? So when Demi Moore's character again completely screwed up the examination of their witnesses, right? Because you might have wanted to find out that they never actually heard the order. That might be a clue that we want to know about. So after Demi Moore completely screwed that up, and the defense's case has gone completely to shit, and their only other witness has now committed suicide, Cappy over here, Tom Cruise's character, is feeling understandably despondent. He's like, I have no witnesses left to call. I have nowhere left to go. I'm totally hosed. And Demi Moore's character, again, this is a slight on Aaron Sorkin for writing it this way, has Demi Moore's character just take him apart, put him against the rails. Like, you put Jessup on that stand, you get it. And Tom Cruise gives what is completely the correct answer, although he's giving it drunkenly and angrily and rudely, but it's the correct answer. So, but he's saying, I can't do that. I can't call Jessup on the stand and ask him about it because I don't have any evidence that would form a basis for the question, which incidentally is also true in civil law and is true in non-military law. I couldn't do it in non-military law either, right? I can't make an accusation against somebody with no basis, right? I can't just be like, maybe the butler did it with nothing, right? I can certainly allude to other particulars, but I can't just throw a particular person under the bus in a non-military case either, right? I have to have some reasonable basis to ask the question, and I have nothing, and Tom Cruise has nothing. So Tom Cruise can't ask that question in a non-military court, and he can't ask it in a military court, and if he asks it in a military court, it comes with additional penalties because he can be court-martialed because superior officer and all the rest of it, right? So Tom Cruise gives a perfectly cogent, albeit drunk, angry, and somewhat berating, but he gives the correct answer of, I can't do that. And Demi Moore's character is just flogging him and be like, you're such a bad lawyer. You have no balls. Where'd you leave your balls? You leave them in your wife's purse, blah, 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 blah. And so Tom Cruise, like, okay, fine, I'll call Jessup to the stand. And the very next day, because this is all happening the next day, the very next day, Jessup is being called to the stand, and just before he comes to the stand, Tom Cruise and Demi Moore meet in an adjacent room or something. And Demi Moore says, how are you feeling, Cappy? And he says, I think Jessup's going to have a rough time. And then she completely backtracks. It's like, well, if you can't get him, don't push it. I'm special counsel, and I have to let you know that if you push it, you could get into a lot of legal trouble. It's like, oh, you're a two-faced bitch, aren't you? Oh, you want it both ways. You want to be able to completely berate Cappy because he doesn't have balls, and the very next day, when he finally succumbs to you and does what you say, now you want to back off and be like, oh, you better make sure that you don't cross the line, or you could get into a lot of trouble. So I fucking hate her character, and it's not incidentally the first time in the movie that happened. It's not the first time in the movie that happened. It's just the most obvious time in the movie it happened. So Aaron Sorkin wrote this really weak, unprincipled, pansy character that Demi Moore played. She's so two-faced and so Oh my God. You know, Aaron Sorkin can eat me. Although I thought he wrote The West Wing very well, so I'm not negative against Aaron Sorkin in general. But that character, man, Lord, why did he have to write such an unpleasant character? What was the goal of that character? Other than be contrarian and stuff. Like, I think you should go down there. I think you should go in. Better not ask him tough questions, though. I might get in trouble. Brandon Grant says, I just jumped on here, but I'm interested in learning more about David Ramsey lawsuits. Will you be covering them? I have no idea who Dave Ramsey is, so probably not. No, I have no idea who that is. Do I? I don't think I do. Joseph says, Demi, not the least bit self-aware. Remember, Commander, get yourself a cup of coffee. No thanks, I'm fine, sir. Please step out of the room so we can talk about you behind your back. Yeah, she's completely self-unaware. She's completely unable to read innuendo. And she covers her six more than any fighter ever has. You better call him to the stand. You get him on this. You get him on the stand, and you get it from him. Oh, I get it from him. I get it from him. What a great idea! You know, after I go and call him to stand and accuse him of doing this code red with no evidence, guess what happens next? Wrong answer. You know, your clients are convicted, and meanwhile, for you, it's a court martial. That's right. After accusing a senior officer with absolutely no evidence, well, I could do something so galactically stupid as calling him to the stand and accusing him. Debbie was like, "You're such a coward." Blah blah blah. Next day, oh, you better be sure. You better be sure because you can't get it to pushy caffeine. Horrible character. Horrible character. Vic's name is actually pronounced McNonia. Well, whatever it is, we are just pronouncing it the way it is. So, deal. How can I be an unpaid intern for you, Uncivil? I'm in Texas School for Legal Studies and need some practical experience. Any ideas? Not for legal experience, my friend, no. If you want to help edit or something, let me know on Discord. Carrie's non-expansion of 2A was common priority outside the home. Well, exactly the definitions of those boundaries is exactly why we do the deep dive. It was common outside the home. Yeah, under what terms, under what circumstances, blah, 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 blah. Let's do some deep analysis, yeah. Stephanie says that was amazing. Thank you, Stephanie. I appreciate it. Hate that movie so much. I hate that character so much. She's just the worst woman ever. That's also, too, I think it's an insult to women. I think it's a badly written female character in particular. Because it has this very uncomfortable vibe of the continuous nag, right? It has this, especially for a woman who is in the military and is an officer and apparently been there for some time, who apparently would know some discipline and stuff like that. It's like she has this thing of that she never knows what she wants. And as a woman, as soon as she gets what she wants, she doesn't want it anymore. She's this very mercurial, mercurial's the wrong word. You can never make her happy. You can never make her happy. Whatever decision you make, it's the wrong one. And I told you so, right? It's this position of I told you so, I told you so. So no matter what you do, it's like, I told you so. I told you should have called him. I told you shouldn't have called him. It's like, someone who gets exactly what they want and then doesn't want it anymore. She's undefined. She's two-faced. She's a bit of a hag who she cannot be pleased. And she's a complete annoying character, too. She's so annoying, too. She's like a Karen or something. Aaron Sorkin wrote a Karen. It's really bad. Joseph says you could do movie reviews. Maybe I should, man. 12 Angry... Yeah. Yeah, that movie sucks. If you cannot be trusted with all your rights, you'd be let out of jail. I don't know what that question means. I'm sure it's responding snarkily to something I said, and which I said. Try to pay attention more. It'd be nice to see this make it the next SCOTUS. Irony, if these states would just issue the permits, there won't be an issue. I'll tell you what, Michelle, and I'll make this a general offer. Because I think that's fair. We've done $25 for any legal opinion. All right, so if you really want me to cover a case, for $25, I'll cover any specific legal filing. How about that? And it would help if it's in federal court. Otherwise, you might have to give it to me because state courts are a pain in the ass. So we'll modify it. For $25, I'll cover any specific filing in any federal case. How about that? So if you really want me to cover it, there you go. $25, and I will cover the specific legal filing of your choice. Please let me know which legal filing you want me to cover as part of the fee. How about that? That sounds fair. Please give me the court. Please give me the name of the parties, the court, and what specific filing you want, so I can find it. Gun laws need to be addressed in a sensible and consistent way. For example, in New Jersey, automatic weapons are illegal to buy, but you can buy the conversion kit. How does that make any logical sense? Well, you can't convert a semi-auto into auto. That's illegal federally. So the kit does you no good. You can't convert a semi-auto into auto. That's illegal. I hope you know that. A Time to Kill, hands down the best movie. I think that it's okay to require a permit if permits are shall issue, as the state has proven you're somehow legally barred from owning a gun, versus citizens having proved the need. That might be perfectly reasonable, yes. Cable says that's enough about women in general. We're asking for specifics about the character. Cable, that's not fair. All women are not like that. That's mean. That's mean. Posting for the algorithm. Always appreciate the postings for the algorithm. If this stands, we need permits and fees for every constitutional right. That doesn't quite follow. You do need permits and fees sometimes for constitutional rights. I mean, you have the right to conduct a parade, but you might need to file a permit for it. You might have the right to assembly, but if the assembly is big enough, you might need to have a permit for it. So yeah, and if you want to have a newspaper, you don't necessarily need a permit in so much as you don't exactly need a permit for the newspaper, but you do need a permit for the business otherwise, right? So yeah, the idea that you might need permits and fees for some of the constitutional rights, it's not exactly completely foreign. So yeah, I mean, to some degree maybe. So, but it doesn't quite follow. No, that doesn't work. How inaccurate is the Rainmaker? Rainmaker's pretty freaking accurate. Rainmaker's pretty accurate. I'm trying to think in terms of law, it's pretty good. It's pretty good, all things considered. For a movie, it's pretty solid. Argue bad faith criticism from Law Twitter. Law Twitter is, yeah. 12 Angry Men is a great movie. Paging Al Gorham. I don't know what that means. Most teachers are county's employees. Okay. Noted. I'm not sure. Okay, but noted. Where's the hat? I always wear the hat sometimes these days. Timestamps of questions. Doing the timestamps is just a pain in the ass. It's a total pain in the ass to do timestamps. Just says the permit for a parade is check the rights of people impacted by disruption. Yeah, partially. Yeah, but the fundamental point was not like the purpose for it, but the idea that you can have fees and applications with respect to execution of rights is not like completely foreign, was my point. So in the case of the permit for the marches, and yeah, it would be the conflicts check. It would be making sure that depending on the size of the crowd, what facilities might need to be available, preparations that might need to be made, trash cleanup, blah, blah, blah. So yeah, I mean, my only point was you have a right to do it. You might need to pay a fee. You might need to have a plan. You might need to file some paperwork. So that was only my point was. I've heard the appeal of Vic Mignogna submitted, and hopefully things go better. Anytime the Court of Appeals wants to decide, that will be just fine. I heard they're doing a remake, 12 Angry Them. Cute. Yeah, they took away cheer, whether it means cheerleading or not, I don't know. Yeah, so it says in a school context it means cheerleading. And I said, it is an elementary school. And then people said there's sometimes cheerleading in elementary schools. So whether or not take away cheer refers to cheerleading or not, I leave to your judgment on this issue because I'm not sure, but okay, whatever. Funny that the court found there's no conspiracy when two completely independent agencies took the same action with following procedures. Pan can also mean devil. Pan means devil? I did not know that. "12 Angry Me" is a very good movie. "To Kill a Mockingbird," pretty decent. "A Man for All Seasons." Mike, The Devil's Advocate. Devil's Advocate is not really a great movie. I didn't really like it the first time, and it's okay, but Legally Blonde is somehow better, which is sad. In response to the Ohio bar exam, the intentional infliction of emotional distress, we eventually got there. Oh yeah, so now we're a week old. We're in the comments we discussed last week. So yeah, basically went through all the comments for last week, all the ones I wanted to respond to anyway. How fun! So yeah, that exhausts all the comments we had for the last week that I thought that were worthy of being responded to. So yay! I don't know, we've already done that before. We've actually responded to every single comment that was kind of worthy of mention, and all the ones too. So hey, that was cool. Movies good. Peter Sellers much. Dr. Strangelove. Dr. Strangelove is pretty solid. It's a good movie. Yeah, I like Dr. Strangelove, and it's the Red Alert one that was filmed at basically the same time. That's a more serious take on the same subject. It's pretty interesting. One of my favorite guns. Well, I mean, the ones I have now are Glock. I sold my rifle and I sold my shotgun. So all I have now are handguns. And Stephanie looks at me with a frowny face and she says, "You sold a shotgun and sold a rifle, and now all you have left is handguns?" Stephanie's looking at me with cross eyes. Yes, I sold a shotgun and a rifle, and now all I have left is handguns. Yeah. But anyways, yeah. So I have Glock is the one that I have the most. It's a fine firearm. It works great, and it does everything I need it to do. So why not? The Walther PPQ is really nice on the trigger, though. I was thinking about maybe switching out for the Walther, but yeah. So we'll see how that is. I guess I'm going to sign off for the moment. So she's looking at me more cross-eyed over Glock. Man, not a fan of the Glock, Stephanie. It is the service weapon of choice, as I'm sure you well know. What's your Les Baer? A Les Baer is a fine firearm if you like that. It's a fine firearm. It's a little bit, it's a little much for me, but it's fine firearm choice. Anyways, question of reasonable doubt. A Time to Kill. Time to Kill's a fine movie. She doesn't want the Tupperware. That's fine. 6 Hours. 6 Hours fine. It's just kind of expensive versus his competitors, but it's a perfectly fine firearm. And I mean, it is probably the second most popular choice for a reason. And they make some great stuff too. Yeah. All right. If you're enjoying this legal education content and gun related content, please remember to subscribe. If you're liking this video, even if you dislike Glocks, you can like the video, right? So please give it a like. And for 99 cents, you can become a member of the channel. It's true. Hit the button and help to support us with a recurring membership. Until later, my friends, I hope all is well. Cheers and goodbye.